Salutations, respected viewers. This is George from Ireland. So here I am outside the old land registry. So where could be more apposite to talk about land registration in England and Wales than right in front of this building, formerly the land registry. There are now several land registry buildings in England and Wales. The main one is in Croydon, moved out about 12 years ago, and there's several minor ones around the country. So land registration acts, there have been several of them, dating back to about the 1860s. There was another one in 1922, if memory serves, so shortly after the First World War. That was because so many people had been killed in the First World War, major landowners, in many cases, land had changed hands, there was inheritance, there were death duties. If someone dies, then the estate is over a certain value, there's a high tax paid to inherit that estate, and death duties have been increased very considerably when Lloyd George was Chancellor Exchequer before the First World War. Now, why does England and Wales not simply order that all land be immediately registered? Well, that's because there was strong resistance to this from those who were major landholders. They didn't want people to know quite how much they owned, who owned what, things like that. And then there was another Land Registration Act under Blair in about 2002. So there's certain events which would trigger land registration, as in selling it, lease of longer than a certain period, things of that nature. So remember the three principles of land registration. There is the mirror principle, that the land registry should reflect the situation, who owns what. There's also the curtain principle, insofar as certain things are kept off the land register, and indeed there's the insurance principle. If the land registry says that you own it, that's it, no doubt about it. Now, buying unregistered land is trickier because people would look for root of title, and solicitors have to look at the title deeds, follow the documents back centuries in some cases. It can be very complicated, and it's very tricky in the old days to work out who actually owned what. I mean, occasionally it still is. But as more and more land is on the land registry, this is less and less of an issue. About 90% of land is now on the land registry. And it's astonishing to see that some land has been in the hands of the same family for centuries, going back to the Norman Conquest in a few cases, and therefore still not on the land registry. So that's that. It's a matter of public interest. We can find out who owns what. But there are flaws in all these three principles, because sometimes the mirror principle is not very effective because people have trusts based in the British Virgin Islands or some other offshore place, and a trust owns it. Who is the beneficial owner? Who is hiding behind that? Could be a British person, could be someone from overseas who actually owns this, but they don't want the public to know who actually owns what. They're very secretive about what their assets are, things of that nature. So this is the land registry, as you know, and you can go online and find out quite a lot. So it's scintillating. Land law, as we commonly call it, or the law proper to be more accurate, because these principles don't simply apply to land. When I say land, obviously I mean buildings as well, real estate or realty. But many of these principles also apply to movable goods, although there's no registry for most movable goods. Indeed intellectual property. Well, that's enough about land registration for the moment.